Hello, welcome to our next lecture. We are rapidly approaching the end of the semester. I hope you enjoyed last week's assignment. Hopefully that was a good opportunity to read case law on your own and to start wrestling with facts. That's largely what the practice of law involves. It's taking, again, existing precedent, right? Stare decisis, what has already been decided, and let's stand by those things. But we have new facts, and we have new situations, and we have new disputes and turmoil. And so our job as attorneys, when we're thinking like attorneys and attempting to reason and persuade like attorneys, is to take the new facts and think about it through the lens of existing case law, existing precedent. So this week's case, hopefully it seems relevant. Hopefully you see some of the common rhetoric perhaps being used with current and former presidents in recent times. But this is a crucial case in the jurisprudence of the United States because it really gets to the heart of the separation of powers and what sort of abilities and checks and balances each branch has over the other respective branches. So, of course, in this case, we are dealing with the Watergate scandal. I think it's more or less a joke at this point, but anything, I guess, that seems controversial has gate thrown on the end, and that's largely because of this case that we'll deal with and really the implications that came from the facts of this case. So this building back here, I believe, is the Watergate Hotel. That's where we will begin this week's lecture and keep moving on from there. Before we get to the facts of the case, though, I think it's appropriate to recenter ourselves on the nature of jurisdiction, right? What is jurisdiction? How do we come to reconcile jurisdiction in light of all these different positions of authority that may be over us at any one given point in time? So this was from our very first introductory lesson, dealing with these concentric triangles, right? We know, we talked about the home. We had that very first example case, no food out of the kitchen, or no food in the living room, whatever it was, the law was in the home. And then we saw how certain opinions were rendered that basically interpreted the meaning of that law. Then moving out, we know that there are city ordinances, there are things like traffic laws, and there are zoning laws, things of that nature. Going out even further, there are certain state laws. Some things that are illegal in one state are in fact legal in other states. It varies across states with regard to particular laws. And of course, zooming out even further, going to our federal jurisdiction and what sort of laws are on the books for the United States of America, and how more times than not, federal law will supersede state law and, of course, city law or anything else going on in your home. But all of that to say, though, is we are all subject to the law of Christ. We as Christians believe that Christ is the author and perfecter of our faith. And again, as we talked about from the very beginning, the law that we know as of today, and especially back in the Old Testament times, the Old Covenant law, the Mosaic law, it was just a shadow, right? That law was just a shadow of the good and perfect, true law of Christ. We as sinners can never administer perfect justice. It will never happen. We will always fall short. We will always miss the mark. And in light of that, our jurisprudence and our jurisdictions may attempt, right? We may believe that they will attempt at true good and just results, but we will always fall short. So, with that being said, though, knowing that we are, again, all subject to the law of Christ, it's important to recognize this separation of powers, the checks and balances. We won't really get into the political philosophy side of things, the theoretical approach, but for our purposes in this case, it's important to recognize the three distinct branches that our United States government operates within. So we have the executive branch, we have the legislative branch, and we have the judicial branch. Each one of these branches has power over the other two. It's an incredible system that our founding fathers were able to devise and think through, and studied several forms of government through antiquity, and were able to argue and debate and effectually draft not only the Declaration of Independence, but ultimately the Articles of Confederation, and then eventually the United States Constitution, which, of course, provide room to amend that Constitution, as we've seen time and time again, amendments to the Constitution, but nevertheless has provided this incredible system whereby each branch is tasked with a given job to do to ensure our government, our federal government as a whole, can work, can govern its people well. Of course, theory, we can talk about that in particulars, but that's at least the operating theory we're under right now. In this case that we're going to get to is a sort of debate or tension or dispute between the executive branch, the president, and really the court system, the judicial branch. And with regard to the executive branch, how much power can the president claim? How much power can the president say that he is entitled to, or how much power can the president read into the Constitution for himself? And at what point in time are the courts there to check that power, right, to balance out that power? Of course, the president is ultimately able to appoint justices to the bench. The legislature branch, of course, gets to say or create, rather, what the laws are or should be. And the judicial branch, like we saw in Marbury v. Madison, is to say what the law is. And the executive branch basically is to enforce it. It's to go and execute on those laws and on the opinions rendered. So, in this case, United States v. Nixon. There is a Nixon v. United States. Very confusing, but that came later, and it was a different Nixon. United States v. Nixon, very, very complicated set of facts. If you're a history person or like conspiracies, then by all means, dig into it, learn more about Watergate. But for our purposes here, we just need to know that President Nixon was involved with a group of people that were attempting to undermine or collect information about a rival political candidate. So they were caught at that hotel, and there were certain documents and other things that they were looking for. And so when the criminal procedure was opened up, because this was a matter of obstructing justice and perhaps conspiring against the United States, it kind of got messy, of course, because politics were involved, and everyone had an interpretation of what it was. This is situated in 1970s. We're dealing with the president now that somehow got involved, or at least had the grand jury that indicted the president had reason to believe he was involved. And so the president was issued a subpoena to produce certain documents, tape recordings of conversations in the Oval Office, memos, other kind of writings as well, to help basically the prosecution start putting together a case against the president, perhaps, but at the very least, these other men that were caught at the Watergate Hotel. So what we need to know now is that there are sensitive documents that come out in trial, essentially. But in this case, it's a criminal procedure. There's a prosecution occurring. The United States Attorney General is acting as a representative of we the people. And so with that comes the need for evidence, right? We talked about that time and time again. We're not going to get into the particulars of evidence, but again, there are certain writings, recordings that could ultimately incriminate a group of people including the president. Now, the issue, though, is that the president is the one who has custody of these documents. So, in other words, the president is the only one that could deliver the documents and the recordings to the prosecutor. The United States is just a party, holistically. But there's sort of an interesting question here now of Fifth Amendment rights, right? We have the right to not incriminate ourselves. We looked at that particularly in the Miranda case. So here, the President Nixon is essentially asserting his right to not release the documents and the recordings, not so much on Fifth Amendment grounds, but under sort of a new theory that he's working with called executive privilege. So executive privilege is not found in the Constitution. It's not a codified right, but it's sort of a theory that is derived from a understanding of the separation of powers. So the argument basically goes something along the lines of needing to have certain parameters and protections with regard to what happens in the executive branch to actually carry out the duties of the executive branch. So if the president, in other words, constantly had someone looking over his shoulder, perhaps the general public, let's say, or one of the other branches, there's a decent argument to be made that he could not execute efficiently. He could not do his job efficiently and run basically the country. He could not run the United States federal government. So that's where this idea of executive privilege comes from. Let me go back to our sweet graphic here, if you can tell how good I am at Photoshop. So the President, Nixon, is essentially fighting against this entire system of evidentiary collection, of process and procedure that's involved for the criminal prosecution of, sure, his co-conspirators as well as himself. But the idea goes something along the lines of, because he's the president and the nature of his role, he is privy and perhaps produces very sensitive information. That sensitive information, though, is pertinent and relevant to running the United States federal government. And because he's running the United States federal government, it necessarily requires him keeping certain information confidential and secret. He has an executive privilege to withhold certain information. Again, claiming executive privilege. The court gets into that, sort of teases out the argument as to whether it's more of an evidentiary privilege, which would be something like attorney-client privilege. If clients are coming to me, generally speaking, they have a privilege such that if they tell me something in confidence as their attorney, I cannot go and say that same thing, whatever it may be, to someone else, especially law enforcement. Priests sometimes have that sort of privilege as well. The privilege belongs to the person, the client, saying the thing, whatever it may be. And so if they waive it, again, like we talked about the Miranda case, someone could waive their First Amendment rights to remain silent or to have counsel, but it's ultimately their privilege. So President Nixon is making that same argument, basically, of look, this is the nature of my role as president, as the commander-in-chief. I have certain sensitive information that is necessary for running the government, and because of that sensitive information and because of who I am, I have an executive privilege. So ultimately, I, as president, get to decide what sort of information is given or shared or otherwise disseminated to either the other branches, other agencies, or the general public. The issue, though, to kind of go back to context a little bit, is that there was a decent uproar with regard to this Watergate scandal. So the criminal prosecution is going on. You can look at, Nixon fired some guys, and that also caused a stir. And so ultimately what he decides to do is release sort of a partially fulfill that request. So here's some documents, here's some recordings, and he was hoping that would at least placate his public perception, or the general public, or even the prosecutor himself, of saying, look, here's what I got, I think this is fine. But notably, it wouldn't incriminate himself, right? There wouldn't be recordings there that would show his role, or at least prove up his role in this conspiracy to undermine this political rival or obstruct justice, whatever it may have been. So the President Nixon, again, makes this sort of argument. There's an executive privilege. And so even though the United States criminal justice system is operating and functioning and doing what it can to proceed with the promulgation of justice, right? Seeing that justice is done, seeing that guilt does not escape, and that innocence is not trampled over, he steps in line, or steps in the middle of this operational system to say, nope, I have executive privilege. I do not have to release these documents or these recordings. And so ultimately, you, the criminal justice system, have to essentially submit or be inferior or subordinate to me as president in this situation. So here's a separation of powers argument now. Let's see if I can flip over the case real quick. Read that a little bit. So it says first ground. So he's got two grounds to claim his absolute privilege. The first ground is the valid need for protection of communications between high government officials and those who advise and assist them in the performance of their manifold duties, like we just discussed. And then here's the second reason. The second ground asserted by the President's Counsel in support of the claim of absolute privilege rests on the doctrine of separation of powers. Here it is argued that the independence of the executive branch within its own sphere insulates a president from a judicial subpoena in an ongoing criminal prosecution and thereby protects confidential presidential communications. Kind of two sides of the same coin here. One, we have sort of a operational principle, and two, we have more of a foundational principle. So it's almost like a stay in your lane. Look, I get that you think that you have something on me from a criminal perspective, something to prosecute me with, but we're going to keep everything separate. So what I do over here in my little corner, or my bubble, I guess I should say, because we have the lovely Venn diagram here. Whatever I do in my little bubble over here is none of the court's concern, essentially. There's no need to bring that to bear because we are, in fact, operating as separate powers. So, court teases with that. You can read that, of course. I'm just getting the high points here, and comes down with I think a pretty good observation here. It says the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed by either the prosecution or by the defense. What we're dealing with here now is, I think, a very noble principle and a very noble ideal. Namely, that the justice system is predicated on the pursuit of truth. So in order to achieve justice, right, to have a fair system that's operating and that is really believed in, right, that the public, the people have confidence in because it maintains a sense of integrity, it requires a full disclosure of all the facts within, of course, the rules of evidence. So, like we talked about it, at least at some point in time, maybe in the Miranda case, I'm not sure, but the goat analogy is what comes back to mind. If we don't have anyone that has seen the guy take the goat, then how are we supposed to ensure justice is done? Right? Or let's just go back to King Solomon and the two prostitutes. No one saw one of the prostitutes take the other's baby, Right? No one saw that, at least as far as we know. Right? We're not given that information. All that we're given is that King Solomon is having to deal with this issue, namely that one lady's baby is no longer with her. At least that's the claim. So then the issue is, which mother does the baby belong to? King Solomon very well could have, started asking questions, gotten some details, tried to challenge the character of one of the prostitutes as far as who would be more likely to take the other baby or who would lie about that. As we know, he does makes a remarkable move and decides to split the baby, right? Cut the baby in half and give each woman one half. Of course, the real mother comes and says, well, wait a second, nope, the other lady can have it, and that's how King Solomon knows. It's a tremendous display of wisdom. So then when we're getting back to here just the judicial system, let's suppose that was the issue. Okay, what we need to know for the judicial system to maintain its sense of integrity is that it is ultimately pursuing truth. Because as soon as we have the truth come to bear, right, that we have the facts before us, then we can best administer justice by virtue of existing case law, wisdom, right, common law, whatever it may be that we can then work with. But we have to have the full disclosure of all the facts. So we need evidence, right? We need the documents. We need the memos. We need the recordings that took place. If we're in a situation, getting back to the present case, if President Nixon knows that he has said and done things that would incriminate him, and those things have been recorded in either memos or audio recordings or whatever it may be, if he's not being forthcoming with that information, then we cannot achieve truth, right? We cannot get to a full disclosure of all the facts because those facts are being withheld from the present case. So if we're in a situation where normally it would just be a matter of criminal procedure, be a matter of evidence, so that looks at how does certain documents or recordings or testimonies, anything like that, how does that actually get into court? It's not like anything said can ever be admitted into the court of law. If you've ever heard of hearsay before, that's a big objection there, the rule against hearsay. And so there's certain standards that are in place to ensure evidence can come into the court of law. But it's predicated on this example that we want as much information as we possibly can. We want a full disclosure of the facts to ensure that when we have two competing sides, basically saying two separate things, when we have all the facts before us, we can then rely on the law to determine the outcome. That's sort of the big picture, the theory of how the legal system works. But I think it's a really good point that there has to be a public confidence in the system, or else it would break down entirely. So let's suppose that President Nixon's executive privilege argument was valid. Let's say that the court said, "Yep, he does have executive privilege." Then what are we starting to look at then with regard to our legal system? Well, there's at least one man who's above the law. Right? If the president does anything that could be criminal in nature, that man couldn't necessarily be fully prosecuted because he wouldn't have to disclose all the facts. He wouldn't have to produce certain documents or wouldn't have to provide certain testimonies or whatever it may be. He would be absolved. Right? He would have that privilege that he could waive to say, yeah, I know this probably looks bad, but I have executive privilege, so no, you don't get to have any of my documents, you don't have to have any of my recordings, any conversations I've had, you don't get anything. Now, of course, he would still have the Fifth Amendment right to not incriminate himself, to point the finger at himself and say, yeah, I took the goat, right, or I obstructed justice, or I took the baby, whatever it may be. But we still need the full disclosure of all the facts. And to have a full disclosure of all the facts, that will ensure that justice can be done. As they say here, to ensure that justice is done, it is imperative to the function of the courts that compulsory process be available for the production of evidence needed by either the prosecution or the defense. So the courts need to have a way to compel a president or any party, right, for the prosecution or the defense, to produce the documents. Let's go back to Marbury v. Madison. Right, we got through the entire case, and the court basically said, look, yep, we see that you have a harm done. We see that the law is the right place to do it, but we're the wrong court for it. Right? They kind of wash their hands of it and step away. It's a similar point here in that the court recognizes its own necessity, perhaps, to ensure that it can compel the production of evidence to ensure that justice is done. If the court took its entire step back and said, you know what, President Nixon, you really should produce those documents, but we can't do anything about it, it almost renders the judicial system meaningless. It has nothing that it can do. It just simply sits back and says, oh, better luck next time. Hopefully they'll know the right thing to do. There has to be sort of a executive function within the judicial branch. There has to be a enforcement mechanism within the judicial branch to ensure that integrity of the judicial system is maintained, that public confidence in the system is maintained, and ultimately that the courts can see that justice is done. So they get into this sort of principle of the separation of powers. They reconcile how the separation of powers occurs, but they're ultimately looking at the entire system here. If the system breaks down and public confidence is lost, there's really no way for justice to still be administered within the scheme that we have. So the court lays down this principle, looks at this and says, no, we need all the facts here. We need a way to compel the evidence to be brought to bear by either the prosecution or the defense. And again, with the understanding that all the facts are before us, and we have the law in place, we can see and ensure that justice is done. So, what that means then for this case is that the specific will control the general. That is a fundamental concept of law. More times than not, you'll see it in different ways, but more times than not, when there is a specific law on point, which means it's relevant, then that will control over a general principle or sort of a rule of thumb. So if there's something that directly addresses a given issue, that's going to be the law or the rule to follow rather than sort of a general principle. So here the court concludes that when the ground for asserting privilege as to subpoenaed materials sought for use in a criminal trial is based only on the generalized interest in confidentiality, it cannot prevail over the fundamental demands of due process of law and the fair administration of criminal justice. The generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. Or, in other words, President Nixon, you are not above the law. That's largely what this case stands for here. There is a decent argument, I think, that the president should have a certain executive privilege. Again, the nature of his role, being able to effectively run the country, to administer the executive responsibilities and obligations. If there was more and more red tape with regard to how he was being reviewed or what sort of checks and balances were in place, or if anything said had to be run through the court system first to make sure that it was quote-unquote legal, then there would be a horrible inefficiency, and arguably the executive branch cannot do its job. It cannot perform its obligations and responsibilities to the best of its ability. So here, the court, I think, makes a good point. Again, we need all the facts. We need the truth to come out, and then we can rely on the law to administer justice appropriately. Otherwise, if someone's above the law, if there's no enforcement mechanism, then we lose public faith, we lose integrity, and the whole system could potentially collapse. Here, it's okay to have a specific assertion of privilege, but what we're dealing with in light of this case, again, the U.S. v. Nixon case, is that there's really only a general assertion of privilege, and we've shown a specific need to get, again, memos, the recordings, the documents, and transcripts to show and to bring all those facts to bear with regard to what happened in this Watergate scandal. Like, what were these guys up to? How far out does it go? How deep does it go? What were they seeking? What were their motives? What were they trying to accomplish? And if we don't have a way to get all those facts compiled, if we can't compel these parties to produce all this evidence, then we lose faith, right? We lose the integrity. We lose the ability to administer justice. So with that sort of operational principle in place, the court concludes that the privilege to withhold information from this prosecutor will become subordinate to the specific need the prosecutor has to administer justice. Or in other words, there's checks and balances. And that's sort of the shortcut here. The president is not above the law. The president is not above criminal procedure. The courts have a way to check that privilege. The courts have a way to compel the president to produce those documents, again, in the name of justice, to ensure that the system itself is fully functional. So we have, going back to the very first slide, we have the jurisdiction in place. We know how these concentric triangles work. When we're looking at the specific branches of government, and there's a decent argument to be made about the separation of powers and ensuring that there's not too much oversight because they wouldn't be separate anymore. They would have the ability to function interdependently. Then that's a good reason to have an executive privilege. However, when there's a specific need to ensure that justice is done, namely to compile this evidence, to see exactly what sort of conversations were had, who told whom what, right? Who was responsible for undermining this justice, to obstruct justice, then by all means the United States has an interest to ensure that the president produces these pieces of evidence that he has in his custody. So that's the ultimate conclusion here. It promotes more limitations on the executive privilege. It ensures there's more accountability for the president. Ultimately, it strengthens the judicial power as well. The judicial power gets to be taken more seriously in light of this sort of landmark decision with regard to presidential power and privileges. Of course, the Watergate scandal is still unfolding during this time. President Nixon ultimately resigns. Again, if you're interested in that sort of conspiracy theory world, by all means dig into it. I'm sure there's plenty of information. I can't necessarily speak to its credibility, but plenty of information nonetheless out there. Public confidence at this time. It's also an interesting historical analysis to look at coming out of the 1960s that we've talked at length about. We're now situated in the 1970s and show public confidence in positions of authority, looking through that sort of lens. Reinforce the checks and balances like we talked about. And then, again, and now in recent times, what do we do with a president who may claim certain privileges and immunities by virtue of his office or former office, right? What do we do with that? How do we reconcile that? There's a lot to be said for executive privilege. If we could just use a quick example, like in a school, student, teacher, principal, and then there may be a head of school and then the school board. That's sort of the concentric triangles again in a given school. We don't need, we as students, let's just use that lower level, don't need to know everything going on at the school board level. The school board needs to make big time decisions for the school to ensure that it can function properly. And likewise, what the teachers do, let's just use that example, what the teachers do on the day-to-day classroom doesn't necessarily need to be shown all the way up to the school board. There's a certain hierarchy involved with regard to how the school is administered. So in other words, if the teachers, let's just say, were constantly being reviewed by the school board, and nothing could be said without their approval first, things would quickly fall apart. And likewise, if there was some sort of accountability group, let's just say, I'm kind of lost the analogy here with the separation of powers, but if the school board had to constantly run its decisions through another governing board, then it'd be hard to imagine any kind of efficiency or any kind of practical application being demonstrated, right? They're constantly having to have someone look over their shoulder. And it's sort of the same principle here with the president. Again, the separation of powers ensures that the executive branch can go and carry out its duties. The judicial branch, legislative branch, same thing. But what do we do when those two conflict? Or when those two things butt heads? Well, the principle we get from this case is that no one is above the law. There are, in fact, checks and balances within the separation of powers. And that's where we're left. We're left with this landmark Supreme Court decision for this result. I thought this would be a good time to get into a little bit more biblical examples as well. When I was going through this case, story of David and Nathan came to mind. So here we have sort of the same principle here. I'll just call it the same principle. So we're in 2 Samuel 12. And the Lord sent Nathan to David. He came to him and said to him, there were two men in a certain city, the one rich and the other poor. The rich man had very many flocks and herds, but the poor man had nothing but one little ewe lamb, which he had bought. And he brought it up and grew it with him and with his children. He used to eat of his morsel and drink from his cup and lie in his arms, and it was like a daughter to him. Now there came a traveler to the rich man, and he was unwilling to take one of his own flock or herd to prepare for the guest who had come to him, but he took the poor man's lamb and prepared it for the man who had come to him. Then David's anger greatly kindled against the man, and he said to Nathan, as the Lord lives, the man who has done this deserves to die, and he shall restore the lamb fourfold, because he did this thing, because he had no pity. So, kind of a weird story. I probably didn't tee that up the best way I could, but this is after David saw Bathsheba bathing on the roof. He has Uriah killed. He takes Bathsheba as one of his wives. And Nathan now is coming to rebuke him. I guess it's funny because I was going to make a point about, we typically gloss this over, and here I am glossing over it, but this was the king. Right? This was King David. This was not a plebeian. This was not a common person. This was the king. So he, by all means, had the right to order his military to do a certain thing. And really, he had the right to take anyone he wanted as his wife. Now, of course, there was Mosaic law and covenants, and we can kind of get into that. But really, the principle here that we should think about and think through is whatever the king did was the law, right? Whatever the king did was right, but it was really right in his own eyes. The beautiful principle we now have here, though, is that David was still subject to God, right? He was still accountable for his sins. And so what does Nathan do, right? Nathan tells this weird little story about rich guy and a poor guy, and the poor guy is the lamb that he loves like a daughter, and the rich man just comes and says, that's mine. I'm taking it. That's for me. So David gets mad, right? He sees the injustice there. Wait a second. Why would the rich man not just use one of his own lambs? He had plenty of lambs. He had all these lambs over here. Why do he have to go over here to this poor guy? This poor guy's lamb, and take that lamb, his only lamb, from him. That's an injustice, and we're going to see that he dies, right? Deserves to die. He should restore the lamb fourfold because he did this thing. But what does Nathan say? Right? What does Nathan say? You are the man. Thus says the Lord, the God of Israel, I anointed you king over Israel, and I delivered you out of the hand of Saul. And I gave you your master's house and your master's wives into your arms, and gave you the house of Israel and of Judah. And if this were too little, I would add to you as much more. Why have you despised the word of the Lord to do what is evil in his sight? So we can dive in that a little bit more, but I think this concept is really good. I think it's really important for our study of law here in this class. The law has to trump all else, right? The law itself is what the third thing is, the tertium quid. So as soon as someone like President Nixon gets to be above that law and say, I can do what I want to do because I'm the president, or King David gets to say, I'm going to do what I'm going to do because I'm the king. Man, that's much more powerful. God's chosen king at that. There's still the fundamental principle here that we're subordinate to the law of Christ. We are still subject to the law of Christ. So sure, we have our modern law, and we see that same principle applied in modern law, but it's, I think, here in the story of Nathan and David as well. Nathan points out David's sin. And it says, you've sinned against God. Isn't it enough that he's given you out of the hand of Saul and all of his property and his wives and power and all that other stuff? Why did you have to go and kill Uriah? Checks and balances, right? King David, Nathan, the kings and the prophets, the priests, we sort of see that principle played out. And we'll be able to think about it a little bit more for our assignment this week. But let me go through one more story with King Nebuchadnezzar as well. From Daniel 4. When Daniel has already interpreted the dreams of Nebuchadnezzar. And so we're starting here in 28, chapter 4, verse 28. All this came upon King Nebuchadnezzar. At the end of the 12 months, he was walking on the roof of the royal palace of Babylon. And the king answered and said, It is not this great Babylon which I have built by my mighty power as a royal residence for the glory of my majesty. Gotta know what's coming. While the words were still in the king's mouth, there fell a voice from heaven, O King Nebuchadnezzar, to you it is spoken. The kingdom has departed from you, and you shall be driven from among men. Your dwelling shall be with the beasts of the field, and you shall be made to eat grass like an ox. And 7 periods of time shall pass over you, until you know that the Most High rules the kingdom of men and gives it to whom he will. Immediately the word was fulfilled against Nebuchadnezzar. He was driven from among men and ate grass like an ox, and his body was wet with the dew of heaven, till his hair grew as long as eagle's feathers, and his nails were like bird claws. I think another interesting principle here. I think it's just worth pointing out, and again, we'll have more time to reflect on this, but we have Nebuchadnezzar look around his kingdom and say, look what I have done, and look how it is glorifying me. It's my city glorifying me and my majesty. What does God immediately do? He calls down and says, No. The Most High rules the kingdom of men. And God gives it to whom he will. So I think it's a similar principle here. Right? We have the jurisdiction of Christ. We know that God is in control. He sets rulers upon thrones and dethrones them at his will. That principle that we are subject to God's law, I think is still seen in our modern law today as well. Sure, we call it different names, but there's this idea still that there's no one branch, there's no one sub-part of our government that trumps any other subpart. Executive branch has to answer to the judicial branch. Judicial branch answers to the legislative branch. Legislative branch answers to the executive branch. And reverse order as well. In the case of U.S. v. Nixon, decent argument that he has the executive privilege, and I think rightly so in some instances, but not an absolute privilege. By no means is the president the absolute authority over our government, over the people. There has to be checks and balances in place to ensure things like criminal procedure can continue in the name of justice. Right? We want all the facts to be gathered together in the name of justice to then allow the law and the system to do its work in light of those facts. If those facts are withheld, or at least not presented or obscured, then justice couldn't be rendered as best it could. We need the truth to come out, and we need to recognize that we're subject to this law, including the President of the United States, right? Including King David, including King Nebuchadnezzar. Okay, I'll end here because I think this kind of sums it up nicely. So now we're in chapter 4 of Daniel. At the end of the days, I, Nebuchadnezzar, lifted my eyes to heaven, and my reason returned to me. Lost his reason, returned to him. And I blessed the Most High, and praised and honored him who lives forever, for his dominion is an everlasting dominion, and his kingdom endures from generation to generation. All the inhabitants of the earth are accounted as nothing, and he does according to his will among the host of heaven and among the inhabitants of the earth. And none can stay his hand or say to him, "What have you done?" At the same time, my reason returned to me, and for the glory of my kingdom, my majesty and splendor returned to me. My counselors and my lords sought me, and I was established in my kingdom, and still more greatness was added to me. Now I, Nebuchadnezzar, praise and extol and honor the King of heaven. For all his works are right, and his ways are just, and those who walk in pride he is able to humble. Law of Christ. Right. We are subject to the law of Christ, and thank God for it. President Nixon, subject to justice, I think is sort of an abstract ideal. But we know, we see, we can recognize where that concept actually comes from. God is the God of all. God is the Lord of all kingdoms, ruler of all heavens and all earth. So, generation to generation as well. Okay, so that wraps it up. Executive privilege, separation of powers, checks and balances, and then ultimately looking at it in light of the jurisdiction that we have, and the goodness and hope that we have, the praise, right, that we have in light of Christ and what he's done. So, as always, if you have any questions, please let me know. Like I said, you'll have more time to wrestle with these concepts, with the reflection questions. But yeah, any other questions, please let me know. If you find anything interesting about the Watergate scandal, I'd love to hear what you're finding too. But hope you have a blessed week, and I will see you next time. Thank you very much.